Hi. Can you all hear me at the back? Lovely. So thank you all for joining. We have a fantastic panel set up today. And I want to begin with a kind of anecdote. So last week, drivers from Uber and Ola went to the Court of Appeal in Amsterdam, challenging labor conditions and management policies of two corporations, Uber and Ola. But unlike traditional labor disputes that you see in court, the challenge here was targeted at the company's algorithmic systems and their data governance, with workers arguing that these platforms need to provide some more clarity on how the companies use data and how they deploy database systems that determine really core aspects of their work and of their livelihoods. So these are challenges that are based on and really are pushing the boundaries of the GDPR, something I think we're all familiar with and all concerned about. Particularly because the implications here are not only important for the individual drivers involved, not just the people who are taking these systems to court or taking these companies to court, but are crucial for all of the drivers on the platform and who kind of operate through platform-mediated labor. They're also interested in the population level or collective insights and interests produced by these platforms, to know how rides are allocated, how ratings are calculated, why some drivers get deactivated while others stay on, transparency requests that are really fundamental to their work and ought to be fundamental to anybody operating under particular labor conditions. Now, the GDPR, however, as we know, is largely focused on individual rights, doesn't clearly establish mechanisms which allow for collectivizing or collective bargaining on data governance practices, and particularly seems to be less and less useful against large corporations and platforms. So, and many of the questions that these legal challenges raise also relate to data and data processing practices whose value is generated in the aggregate and possibly not even really meaningful at an individual level when you disaggregate it. And so it raises also the question about how useful data rights mechanisms like individual consent or data subject access rights or data portability even is in this current context when we have large platforms collecting and aggregating data about, and generating population and group level insights. These questions are also now increasingly relevant outside of the GDPR framing. They're relevant to developments in technology regulation in the EU and elsewhere, such as the Platform Work Directive and the AI Act, which we've had a lot of also like concurrent discussions about. And so the case really captures an important dilemma at the heart of all of our platform-mediated lives, outside of the labor context as well. Does data protection law today offer avenues to protect collective interests, particularly in the face of platforms that take population-level decisions? How can we make data governance work at a collective level? And what legal and technological reforms help us protect these important collective interests? And what perspective, particularly from workers' rights and workers' organizing, tells us about the broader value of collectivizing aspects of data governance? And so where can we go from here? And so to answer all of these questions, which I have none of the answers to, I'm really excited to introduce this wonderful panel on collectively making it work, the flaws of individual approaches to resist platform power. And please note the very clever wordplay with the F in parentheses. So I'll begin by introducing Jill. Jill, who is a PhD researcher at the University of Amsterdam at the Institute for Information Law. Her work looks at data governance and algorithmic management in the platform economy. In particular on the constitutive and transformative potential of the law to construct worker power towards social justice ends. Jill also co-runs the Racism and Technology Center with Naomi Appelman and Hans de Zwart, which is a nonprofit based in the Netherlands. James is the founder and director of Worker Info Exchange, who many of you might have already heard from earlier today and yesterday. And Worker Info Exchange advocates for digital rights for workers in the so-called gig economy, quotes supplied by James, and he's also the general secretary of the ADCU, the App Drivers and Couriers Union. And after leaving a career in technology, James became an activist for workers' rights in the gig economy, and a quite prominent one at that. We also have Anton, who is an independent attorney based in Amsterdam, whose practice focuses on privacy, ICT, and AI. Amongst other influential cases, he has argued for the claimants in the Hague Civil Court, challenging the welfare fraud system, the SIRI, which many of you interested in algorithmic systems would have heard of, He also represents and is representing the drivers challenging Uber and Ola's algorithmic worker management practices in the Amsterdam courts, the example I just supplied to you. We also have IViR, who is a policy officer for fundamental rights policy in the European Commission. He focuses on the effective enforcement of fundamental rights in the digital context, including the AI Act. He's published an anthology called Ethics, with a 3, a reinvention of ethics in the digital age, as well as conducted research on automated profiling. And earlier, he worked as a trainee at the EDPS. We had another panelist, as you might see, Vanessa Bass, who we were also very excited to host, but unfortunately couldn't be here today. And I will try to summarize and stand in a little bit on her behalf. Vanessa works for IG Metall, which is Germany's largest union, and also helped establish FairTube, which is an initiative to improve the conditions of workers on digital platforms, and also helped develop the crowdsourcing code of conduct as a dispute resolution mechanism between platform workers and platforms. I'm Divij Joshi. I'm a doctoral researcher at UCL, and my research focuses on the law and political economy of platform governance. And with that, without further ado, I'm going to ask Jill for her opening statements. You all have 5 minutes for opening statements, after which we will have a moderated question and answer session, and about 20 minutes for all of you. So keep your questions ready. Thank you.
I start? Oh.
Yes.
Okay, hi everyone. Thanks for being here, and thanks Divish for the introduction. I'm a bit nervous, so I apologize if I speak too quickly or I say something wrong about the data protection particularly. So I will not go too deep into data protection because I know there's a room full of experts here, so you have time to speak up in the Q&A. So I think there's 3 kind of points that I want to make with regards to this topic that was introduced really well by Divish, which is the fact that I think on our panel we have people very focused on transport and delivery sectors and the platform economy in general. But I think this is a trend, this increasing datafication of employment and the use of algorithmic management and other forms of surveillance and exploitative practices should make us take heed because it goes into other areas of work. And while we talk about labor, I mean, a lot of us here are workers as well. And I personally feel that that identity is an important identity to also acknowledge beyond just gig workers. And I think in the technology regulation and policy-making space, it hasn't really accommodated to the work perspective. So when you look at different employment relationships in all sorts of jobs, from the start to the end, start is like you have companies like HireView that does like automated hiring, during monitoring employees, using different forms of tracking tools and workplace analytical tools like Microsoft productivity scores, and at the end where you see this the cases on automated dismissals and deactivations. But the thing is that this process of datafication and analytical and algorithmic systems operates and occurs on a collective and population level, right? Sorts people in groups into categories, and it's always relational. And as such, the GDPR has emerged as one way to deal with these issues. But then that's also the issue, and I think you see that a lot with some of the panels here that I've seen yesterday and also today, that there's this idea that the individual, protecting the individual is insufficient because of this relational nature where it extends beyond just the data subject and the data controller. So I think a lot of the dominant narrative, I think, has been about protecting individuals, but you see this increasingly so, that it's kind of evolving towards that. The Platform Work Directive, for example, obviously tackles some of that in terms of collective rights and collective bargaining, and I think that's quite an interesting chapter on algorithmic management, Article 6 and Article 7, that kind of bolsters Article 22 in the GDPR. So in that sense, the GDPR applies to everyone, regardless of employment status, so that differs a little bit. Purpose blind and intent agnostic, right? But it's particularly in a way that because these rights are really broad and abstract, they pushes the responsibilities downstream. So when you think of interpretation, application, enforcement, and it's really to the people trying to assert these rights and try to deal with these rights. And then who suffers the most from like datafication, and technological systems on one hand, but also the challenge of the law, right? And often it's like the most affected, the most vulnerable, the most marginalized communities and individuals that are cut across, race, gender, class, sexuality, disability, etc. And these have like real consequences. And I think it's both the technical and the legal discussion that always happens a lot but never really like try to meaningfully, I think, address like, how can we do better, I guess, as people that work on legal issues and people that work on technical issues. So of course, practical challenges. A lot of you here already know data protection. Okay, it's difficult to exercise your subject access requests. Also a lack of knowledge about their rights. But I think it also extends beyond that, meaning it's not only about knowing about your rights and not only about exercising your rights, but in this entire process that is sustained out, right? Like, so it's super lengthy, super costly. And you have like private companies appealing these processes. You have public authorities not enforcing or not making companies comply to these court decisions, and all the resources, time, money, but also I think trust in a way that if you are already affected and already marginalized on the outskirts of society, you don't really want to be too close to the law as well. Like this entire process, I think, seems to kind of be forgotten a little bit. So I think when we think of litigation, when we think of the law, I think it's really important to consider what your position is in relation to the law that is supposed to protect you. That it doesn't really protect, actually, a lot of people not here in the room. So I think I was talking to James about this, and we were talking about litigation and how litigation is one important aspect in some ways, and that's what individual rights can maybe bring. But at the same time, the idea of organizing and the idea of campaigning is equally, or if not more important. And I think what I want to drag across is that, yes, we can talk about collective rights and collective bargaining, and that's important, and that's what we can learn from the labor perspective. But at the same time, I think we also need to think about collective action. And that includes legal strategies, but also non-legal ones. When we think of, how do we deal and use these rights and the groups of people that are trying to use these rights. So I guess my question a little bit, or not question, but I guess the parting thing that I want to give is, as lawyers, as policymakers, as researchers, how do you kind of think of, or maybe to be in service of collective movements rather than the other way around? And I think trade unions obviously is one way to go, but if you think of historically, trade unions can also be, very much institutionalized and deeply racist and deeply problematic. So I think if we're genuine about claiming power back from private actors or from large institutions that fail to uphold certain values, then I think we need to seriously consider who we're prioritizing in our discussion and in our scholarship and in our policy making. Okay, I'm done. Thank you.
Thanks so much. And absolutely, I think one of the points that you bring about really well illustrated, and to move on to James as well, is about kind of the larger political economy of data governance regulation, about who can claim rights and how they claim rights. And we expect, I think, individuals to go up to DPAs and try to like access their rights or try to challenge these rights, but it becomes incredibly difficult when, as you mentioned, particularly if you're a marginalized actor. James, I'm sure you have a lot of experience in working on this, so I'd love your opening statement as well.
Thank you very much. And if Jill is nervous, I'm doubly so for two reasons. Because one, I'm the imposter. I'm replacing Vanessa. They put a badge on me, and Anton promised to give me dinner tonight. So I don't know anything about anything. The other thing is, I'm surrounded by so many lawyers, and the last time I was in a room with this many lawyers was my wedding day, and it was tense. But it's another story. This panel is about collective action, and so I'm going to give you a bottom-up perspective of that from my perspective. Starting with, I was involved in an employment claim in the UK. It was addressed at the Supreme Court last year, where we were confirmed as workers, and a lot of people think that's the end of the story. No, it's not. We're continuing litigation. We have 4 weeks in the employment tribunal ahead of us in June to just figure out working time. So an employment claim for minimum wage in 2015 it's cost millions of pounds, 6-7 years, and we're still not nearly finished. So there's some reality about how far litigation gets us. But the the importance of data became very clear to me in that process, because during the pleadings for that first tribunal, the Uber lawyers confronted me and said, "You've got a very high cancellation rate. We shouldn't pay you minimum wage. You're turning down half the work we gave you." And they came with these sheets of infographics of all my working practices, and I had nothing that showed that I was turning down all this work, and said, "Look, if this guy's turning down the work, he could sit at home, cancel jobs, sit in the bath, get paid minimum wage." And luckily, we found another document in the bundle from Uber of the onboarding procedure. And the onboarding procedure, and they provided both these documents, but the one on my cancellation rate was a reference week in July 2015 when I worked 91 hours. And I had done 1.49 jobs per hour, but turned down 50% of the work. 1.49 jobs per hour. But then Uber's own document said that if you were working from 40 to 60 hours a week, they expected you to work, you would be completing 1.4 to 1.6 jobs per hour. So at 91 hours, I was at the top end of productivity that Uber expected at 40 to 60 hours. But they were telling the world I didn't deserve the minimum wage. And went on to give evidence before Parliament at the Future World of Work inquiry by the Bayes Department. Same story, 91 hours, who's this guy cancelling all the work, he doesn't deserve minimum wage. And so for me, then I realised that there's an unfair arms race here with data, and the data was being used against us. And I want to say there are three things that I think drive change in this field of worker rights and activism. And I'm no expert, but it seems to me three things are required: organising collective power, real shoe leather organising, old-fashioned. There's no new way of organising through social media. It is, shoe leather being present. The Woody Allen maxim, 50% of success is showing up. You have to do that again and again and again for years. The second is campaigning and communications. We had an uphill battle because in 2015 everybody wanted to be the Uber of this, the Uber of that. Uber was the darling, and we had a communications battle to say, hang on, there's a problem here. And the third is, yes, indeed, strategic litigation, but you can't win with one of those alone. You need all three. You can't win with two of them. You need all three. And so that brings me back to data as an organising principle. We formed ADCEU 2 years ago. We represent about 6,000 drivers. Now we think it's the largest block of gig worker organised labour in Europe. And one of our organising principles in our rule book is around data access, control, and algorithmic explanation. And this was important because when we went to the certification officer in the UK, he said, look, in order to be recognised as a union, you have to be a union. And she said, where's your collective action? What have you done with Uber? Said, well, we sued them. Well, no, that's not collective. That's just litigation. What are you doing collectively with them? I said, well, we're asking for our data. She said, bingo, that's collective action. So it was critical to us being recognised as a trade union that this control and access to data was very, very important for us. So I believe portability is a very important first principle in organising for digital workers, the portability of the data. And it's a right that's framed in terms of marketing lock-in, but it's very important for labour in terms of understanding how much you were earned, how your time was utilised, the quality and the quantity of the work that you were offered. And then I think the other important area, which Anton is an expert in, is automated decision making, the adverse impact it might have upon you for dismissal and hidden performance management, but also in work allocation, this pervasive work allocation, how you're profiled for that. And then finally, this whole new area of security and fraud detection. Fraud, anti-fraud management in apps is the new frontier of misclassification. Contracts don't work anymore, so everything is packaged up as a fraudulent behavior. It's not, it's performance management. And so the explainability factor is really, really important in understanding. I think I'm nearly finished. And finally, another use case beyond employment in terms of this data is in new debates on how cities run road pricing. So Uber's very keen on road pricing, congestion charging, and we're keen on caps, capacity. And a lot of regulators are, enamored with sexy, digital road pricing, real price, dynamic road pricing, and so on. But, when the congestion charge exemption was taken away from Uber drivers in London 2 years ago, the independent impact analysis recognised that Uber would gain market share as a result. Why? Because they can optimize their network smarter than the average bear, but two, because they could push that cost onto labor, and they have. And so we need to be able to be present in that debate, because as you can see what happened in my employment case, that case will be spun against us if we don't have control of our data. So for me, the important issues, portability, explainability of algorithms, I can tell you some horror stories about explanations, and protection from unfair automated decision making. Thank you.
Thanks so much, James. And you mentioned, I think, one of the three core aspects that you mentioned. One of them was strategic litigation, and I think it's quite interesting to be. I've been following Anton's work for a while as well. It's quite interesting to see how tactically the GDPR is used, even though we might recognize its limitations. How tactically it's been used to kind of claim collective rights and claim rights in a collective context. So I'd love to hear from you, Anton.
Yes, thanks. Well, I'd like to use a few minutes to give you a few examples of how to actually collectively make it work. So, and I want to give these examples of the three cases that I've been working on in the last few years. So, the first case was, and I mentioned this morning, there was a Siri case about a risk assessment system used by the Dutch government. And in this case, the approach was basically that there was a coalition of privacy organizations who came together and thought about the priorities in the case and how to, how to work together, how to communicate together in the media, were a very important aspect of it. And then they started the case. And what happened is that after a while, also the FNV, the Dutch Worker Union, joined. So that was very important. And they also decided to engage with a number of public figures that could act as ambassadors on behalf of the case. So they were writing articles, they were appearing in television shows and stuff like that. And finally, this was all even supported by the United Nations, who sent an amicus brief, as they call it in the United States, to the Dutch court, which is very unusual. But I think this shows, from the beginning, actually, this coalition focused on, not even on trying to win the case, because I do remember they even told me, well, we don't really expect to win, but we just want to do this case because it's important. We want to stimulate public debate. We want to make the public aware. So there was, but it was really a bottom-up approach. That's what I liked about it, and it proved to be very successful also. So then, I think in the Uber and Ola cases, there's also really a bottom-up approach, right? Where James, he founded, was one of the founders of the ADCU, bringing together the people that are really affected. And I think it was a very powerful moment last week when you flew with 10 guys from the UK to the courts of Amsterdam. You were present at the hearing. Some people made statements that were really powerful. I could really see that the court was impressed. So I think this bottom-up kind of working is very effective, very powerful. So, but it depends on situations. So I'm also involved in this case against Salesforce and Oracle. This is about the unlawful processing of cookies and online profiles and real-time bidding. But this is a different situation because there we have an affected group of 10 million people, 10 million Dutch internet users. And we have a separate legal entity, the Privacy Collective, that is a claimant in the case. So of course, it's very hard to show up with 10 million people at the court hearing. You know, so it's a slightly different. So then instead we are engaging with partner organizations, with privacy organizations. We're struggling a bit because the district court decided in the first instance that the Privacy Collective did not qualify because they were not representative. But on appeal, we're challenging that decision, and now I'm personally investing a lot of time and energy to engage with those partner organizations. So I think it's a little bit of a bottom-up situation there, but I'm trying to make it, sorry, a bottom-down, how you say, not a bottom-up situation, but I'm trying to make it more like that.
Great.
That's it, yeah.
Thanks so much. And yeah, when you were recounting, Sari, I also remembered how the child benefits scandal in the Netherlands, which brought down a government, I like to think. And
yes,
so I'm guessing I'm guessing there are governments and the European Commission, I'm sure the EU are also concerned about kind of the political implications, trying to develop new regulations about how to kind of control or how to regulate data in these different contexts as well. And who better to talk about this than someone from the EC? So, Heiko.
Yes, thank you all for this conversation. You cannot see my face, but I'm constantly smiling because I have the nice situation that I can speak about a recent proposal from last December, a new platform work directive. And it's a very grateful job because hearing about your difficulties in some ways, I really think that once this will be adopted, it can help, it can matter a lot. And I would also maybe later, I know now I have like 5 minutes, mention a few things about the AI proposal, because actually these two proposals would reinforce each other in some way. And I saw, I don't know if she's here, but somebody at this conference made a nice tweet about it, that the Commission is getting its acts together. And I think it's a nice way to put this. So in the short time we have now, I only want to focus on one chapter of this Platform Work Directive, which is about algorithmic management. The other two chapters are about the recognition of certain people's status as a worker in an employee relationship. And another chapter I will not spend much time on is an obligation on labor platforms to provide transparency to authorities in the sense that they should indicate how many people are working through them in a certain member state. Now on algorithmic management, there are a number of articles that give more transparency to people working through platforms, that give them the possibility to be consulted, their representatives to be consulted about the use of tools for algorithmic management, and also redress, which I think might, given the collective dimension focus of this panel, be an interesting area, because certain automated decisions can then be reviewed and appealed more easily, I dare say, than today, where we already have Article 22 of the GDPR, because many of those provisions in the directive build on the GDPR, but further specify it. Let me give some examples. In the GDPR, of course, to be able to rely on Article 22, the decision-making has to be fully automated. And if it's not a legal effect resulting from it, it has to be similarly significant. Now, on all these concepts, the EDPB already provided guidance. But here in this directive now, there are really concrete examples. That would be, for example, then decisions about scheduling, about remuneration, and other work conditions related decisions. And it would also specify by when and in what format information on such decisions has to be provided to the individual worker as well as to representatives. And another novelty I would like to highlight is that there is the possibility to get review on those decisions that I just mentioned, not only for solely automated ones, but for anyone that are also supported by automated means. So this, of course, helps, first of all, with legal certainty quite a lot, and it broadens the usability of it all. Now let me see, I have 1.5 more minutes. Yes, then I wanted to mention that also important for the collective dimension, there would now be an obligation on the labor platforms in scope to evaluate how the individual decisions that they automate have an effect on the working conditions for the people working through them. So there is this systemic approach, and they have to evaluate this. And maybe if we have time later, there is a bit of a split, because there is also something about health and safety at work, which would only be for genuine employees, whereas everything else I spoke about until now, and that's also important to mention, applies to both people who would be qualified as employees and genuinely self-employed people working through the platform. So that's, I think, also interesting, because it's based on Article 153 on labor and Article 16 data protection, where it specifies the data protection regime. But it's not only about employees, it's also about the independent self-employed people. The last point I want to mention is the bridge to the AI Act, because in one Article 16, it's proposed to regulate that evidence has to be given by the platform when there is a case where a working person brings a claim. And in some cases, one challenge that we are aware of at the Commission is that the evidence just doesn't exist. And under the AI Act, there is a documentation on those who build a system, the provider, to test what they build, to document the results from those tests. And I think, James, you have mentioned that access to data can be a very important hurdle, or also you spoke about functionalities being presented as for fraud detection, whereas you say they are about performance management. Now, under the AI Act, you have to really document the intended purpose. You have to show what you optimize for. You have to show the capabilities and the limitations of the system. So it would become much more difficult in the case of a platform that would also be the provider of the system to say, no, but it's for this purpose, when there's a lot of documentation on how it actually works. So that was for the bridge. I think I stop here and look forward to more. Thanks.
Thanks so much. And I also wanted to summarize what Vanessa Barth wanted to say. Unfortunately, she can't be here. But, and I think it was a point brought up by multiple speakers over here in terms of thinking very specifically about worker rights and labor rights in this context. In recognizing very specifically that while working conditions in the platform economy might have changed, in our conversation she repeatedly stressed that it's still imperative that we recognize platform-mediated labor as labor, and that we recognize the rights that these people, that people working on these platforms have as workers, and so, which requires, I think, for them, and then again, just summarizing, a different approach from just treating workers as data subjects or as consumers, which is not sufficient, because when your everyday livelihood is subject to kind of the whims and subject to platform power, you require more detailed and robust transparency, which again, I think needs to operate at almost an everyday level. Which is why I think they have developed mechanisms like the crowdsourcing code of conduct at IG Metall, which essentially operates as kind of a dispute resolution mechanism between workers and between platforms. Of course, that's entirely voluntary in that context. But also the Fair Work project, which kind of has also been successful in terms of taking up the challenges of speaking on behalf of platform workers who might otherwise not be really considered. For example, content creators on different websites who might not be considered traditional workers or traditional laborers, and often are just stonewalled from receiving any kind of transparency, even though it's integral to their lifestyle, and they contribute so much to the operation of the platform itself. So I think, I think the problem there, of course, is the fact that this kind of labor operates in an almost disaggregated condition with very few ways to actually collectivize. There are like practical limitations to actually collectivizing when you're kind of atomized as content creators all over the world or all over a particular place. And platforms maybe often also try to strategically use that, as Jill said, the the economy or the kind of the ways in which they tactically use laws allows them to evade their responsibility towards workers as well. which is why I think these kinds of initiatives that Vanessa and IG Metal have been developing are really, really interesting. So we're going to go now to a moderated question and answers, first between us and then with with everybody who's here. And I think my first question is kind of for everyone, really. It's a broad conceptual question, but also one, which considers kind of the practical challenges you've faced, because we've been thinking about kind of, we've been having these conversations largely in the context of the GDPR. And so my question, and I'll start with you, Joel, is kind of what does the GDPR not capture that we need to be capturing in terms of collective interests?
I mean, I think maybe to reiterate a bit what I said at the start, which is that it's really like it's an individual right? So that's like, on a good part, which is the very fact that, okay, if you live in here and you're covered by that right, but then at the same time, from the perspective that I provided, is the fact that it just either if you speak to James or Yassine, if you speak to the people who are affected by these systems, they just don't know about these rights to begin with. I mean, I'm not going to talk about, I think I'm not a GDPR scholar, a legal scholar, so I'm not going to go into the provisions of that. But I think it's a matter of understanding the broader picture of where the right exists, and what does that mean in terms of, maybe there has been a lot of work already done on interpreting certain rights. There's, I think, also Article 88 that is specific in the GDPR to the employment context, but I haven't really seen that being fully explored as well. But I think the key thing is that we think about rights as, in some way, a very powerful tool, but we also forget that a lot of people that should, be protected by these rights are still not protected by these rights. And I guess, yeah, you can say it's a GDPR thing, you can say it's generally maybe across the board of law, but I guess that's also the discussion that I'm getting at in terms of how we view the law.
James, same question, but a slightly different one, I think, from the specific perspective of you trying to build this worker data trust at worker exchange, and how data portability has been conceptualized, as you said, as a kind of competition, something to regulate competition and individual data access, but you're using it in a very different way. And so tactically, what challenges has that thrown up? And do you think, say, the portability issue needs to be re-looked at? Because I know even in the cases, it's been a challenge to get that kind of access.
Yeah, it does need to be looked at, because I'm interested in building collective union worker power. It's going to be the fastest way to resolutions, fastest way to bargaining a negotiated settlement, and access to data is really, really important for that. Litigation is great, takes time, and maybe we get lucky, maybe we don't. But the GDPR, it's precarious rights for precarious workers. I mean, we're really grasping at straws here. And in court last week, we had a little WhatsApp group, and one of the drivers that was over with us and was watching this whole thing intently, but hadn't been so much involved in it. He said in the group, he said, I thought GDPR was to protect innocent people, not for Uber and Ola to use as a shield against us. And so that's, we're the invaders, like we're the invading hordes trying to get into this workplace that we're supposed to work in. I mean, and Uber, Ola and these other people are setting themselves up as the protector of rights against us. So it's really strange dynamic going on there. And yeah, so I mean, access to data. Also, we're just seeing very maybe immature regulation and enforcement. Some of the things when we challenge for explanation, with two major gig economy platforms. One we complemented, and the other we didn't. but both of them immediately changed their privacy policy relating to automated decision making. The first one was Deliveroo. They say, we do automated decision making for everything to do with work allocation because we couldn't possibly humanly do it otherwise. And we said, well, good, thank you for being, upfront about that. What did they do? They chuck it all out in case it might trigger something, that we might look at. Free Now is another one. They say they use random forest algorithms to detect fraudulent patterns of behavior, and then they'll use this in the matching process. And we said, oh, that's interesting. Could you tell us more about that? Because it seems a bit mad. And I said, okay, hang on 1 minute. Completely did the privacy policy, took it all out, which leaves us as workers with the question, well, were you ever doing it? Are you not doing it now? Were you never doing it? Like, what's going on? So we're in a very silly situation with some of these rights where we're the invading horde, and, I don't know, who's the enemy? I don't know, sorry.
Thanks.
I fully agree. What I think is funny also is, of course, the debate on GDPR is mainly focused on privacy and data protection, but in these cases that we're doing, the drivers are not pursuing privacy or data protection. And Article 22, to them, has nothing to do with those issues. It's about the effects of automation. So, and which can be many different effects in the labor law context, but also just financially, and or immaterial damages for being accused of something, which is not. It has some relationship with privacy, but it's also much broader than that. So, in a way, you could say that Article 22. I understand that it's in the GDPR, but in a way, it doesn't really make sense. Maybe it should be somewhere else, because the issue of automation is much broader than just the privacy and data protection. So one of the interesting things will be, and I think you mentioned it also, Eike, is how Article 22 will interact with AI Act and Platform Work Directive. Will be something I will think about in the near future.
Thanks. And actually, that would be great if I could. It was what I was going to ask you as well. What is the interplay between these upcoming acts going to look like? What do you think? How do you think it's going to play out with different legislations covering the same field for different categories of people as well?
Yeah. Of course, I asked you to give me that question in a way. But maybe as a brief reaction to you, Anton, I mean, yes, the GDPR is a data protection law, but of course, it's about all the rights and freedoms of the data subject in the processing of their personal data. And I think that can be used. And one of those who show that is exactly you. So thanks for that. Okay. Yes, then for the interplay, I mentioned already that it would help to have evidence about how a system works in order to make use of the entitlement to evidence under the proposed platform directive. And so this is, I think, one of the achievements of the proposed AI Act, if and when adopted, because most of the rules in that proposal would apply to high-risk AI systems. And one category of such systems, they are all in Annex 3, they are listed in Annex 3, is the use in the area of employment. So it starts with recruitment, even with advertising vacancies, but then also anything that we could here call algorithmic management. And so where you build a system for such purposes, you have to really, I will be brief on this because I mentioned it in the beginning, document a lot how you do it. And one detail maybe that could be important here is in documenting how it works, it has to be done not only overall, but also in terms of the different populations that would be targeted by the system. So this, of course, goes to enable those who build the system to comply with non-discrimination rules and to see, okay, if I'm building something for hiring or for promotion, I have to actually see how the system performs on the different populations that I intend to work with. So this flows from the AI proposal to the platform work directive. But there is also, I think, an important point which is about the use of systems, because the AI Act, it's a bit complicated. Most of it is about how the systems are built, but there are also some provisions about its use. And of course, here in the Platform Work Directive, and I want to mention also one other proposal, which is the new Consumer Credit Directive, there it's about the use. And those two proposals are not limited to AI, which is in a way great, because there's a huge debate ongoing about how to define it. Here it's just automation used to take certain decisions. And in both proposals, the platform and the credit, consumer credits, it is not any more limited to the full automation. And you can do that, you can propose that, because you see the context, you see that it makes sense to help the people. There is something at stake for them, and it can be proportionate to then request from a lender or a labor platform to make the effort to also, because it costs resources, to explain the decision, to have staff available for review, to provide clear and written reasons within 1 week or 2 weeks on how those important decisions were taken. So here, the use of automation comes with certain duties that include the explanation of those decisions. And that's maybe one, and I realize I'm speaking for a while now, so I will just say this and then stop. One interesting point here is, because I think, James, you also mentioned explanations. So the duty to explain is here in the Platform Work Directive or in the Consumer Credit Directive, and it's the entity that decides that has to provide the explanation. There is nothing in the AI Act that says explanation, at least not in the version that the Commission proposed. It is about interpretability of the system to the user of the system, because the user will be the one who has to explain their decision. And I think, especially where a tool doesn't work with causality, but with correlations and probability, that's a very important nuance. Yes, thanks.
Thank you. It's quite interesting because, these are all lumped up as, they operate over the same field, but again, they still remain somewhat individual-centric in many ways, either structural or kind of individual-centric approaches. Which brings me to a kind of quick fire round before we open it to them, right? Which is, let's think forward for a bit. Let's see, what do we want out of regulation and law, or out of even platforms in this context? When we think about, we've been talking about labor, but I've also heard different things about labor. Everything we're doing on platforms is labor, one approach. Labor continues to be labor despite it being mediated by platforms, a slightly different conceptual approach. But so in 30 seconds, if you would, how do we make collective rights work in the data context? Yeah.
I'm gonna solve the world's problems. I don't know. I genuinely do not know how do we make collective rights work. I think maybe I'm gonna dodge that question, and then maybe I think respond to kind of this whole development of new technology, new regulation, etc. And I think the question is that with all the proposals on the table, and the EU really pushing to be a regulator of technology companies and of data and of AI, the question is also just, always a big thing, enforcement, but also who gets to be involved in policy making. Civil society is obviously very stretched already. So yeah, increasing regulation, I think, can be helpful, but then who's getting to be part of the discussion? And I think for James and the things that ADCU and the Workers Info Exchange are doing, and part of why they want to get data is because you will not be heard if you don't have evidence, because of this evidence-based policy-making paradigm that we're in. So I think thinking about co-determination, and some of the labor lawyers are talking about co-determination of technology encoded through the law, but also co-determination of laws, right? And who gets to go into these discussions. I think that really matters more than necessarily, just more regulation for the sake of it. Yeah.
Thank you. James?
Well, when I think about the employment law argument, so it's very good that there's the presumption of employment in the platform directive. We didn't have the benefit of that presumption, and so we're still fighting. 4 weeks in court next month. I haven't seen a penny yet from my 2015 claim. So that's how important the presumption in your favour as a vulnerable person really is. And I think it's the same problem in a way with the GDPR. The presumption is the protection of the individual, the protection of the consumer, and then we as the workers are kind of on the outside trying to, make these rights fit for us, but institutionally it's all set up against us somehow. So that doesn't really work. And the problem is it's not just access to data and explainability, but also the growing application of certain technologies like surveillance tech, facial recognition, because we've seen that in the UK has been a bit of an arms race of facial recognition, geolocation, checking, surveillance. For example, there's a requirement to report these deactivations to Transport for London, and in the year after Uber introduced real-time identification, facial recognition, geolocation checking, the number of these referrals to Transport for London jumped up from 390 in 2019-20, and then it was 4,500, and then the year after Uber got their license back, with this as a condition of license, it went to 10,600, almost a quarter of the workforce being referred to the regulator. And so these are very sensitive technologies, and we have found howling errors where people have been immediately revoked, they've had to go to court, and we always win these cases, and we win them one or two ways. We win them in showing that the technology failed, or we win in saying to the judge, listen, we asked for the data, we asked for the explanation, we were entitled to it, they wouldn't give it to us, so we can't defend ourselves. And then the judge will usually rule in our favour. Not a very satisfactory situation, not a very satisfactory way to assert and use your rights. So we need something a bit better than what we have. Thank you.
Thank you. Well, my answer... Can you hear me? Yeah. Last week at the hearing, one of the drivers was wearing a T-shirt with the ADCU logo. It said, "Never give up, never give up." So they promised to send me the same T-shirt as well. So when I come home, it will be there. One issue that I try to address during the case is the issue of the burden of proof with regards to automation and human interference, for example. So I was arguing, based on the Dutch rules of civil litigation, that the burden of proof with regards to the human interference, to the extent that Uber was arguing that there was meaningful human interference, the burden of proof should be with Uber. So we'll see what the Court of Appeal decides. If they decide the burden of proof is with the drivers, we can just throw Article 22 in the bin. It's useless. So we'll see what the Court of Appeal decides, but I can imagine we should also regulate this on a European level. So maybe I can think about that after this session. Yeah.
Great. I kind of still remember the question. On the
how do we make collective data rights work?
Yes, I really have to admit I never understood that. Because the fundamental rights I know are individual rights, and I see collective dimensions, like working conditions, or I see also we have a right to a high level of consumer protection, maybe, and environmental protection. But I can't speak about things I don't understand very much. So maybe something that comes close to it, and to again make an advertisement for the recent proposal, is that in the proposed platform work directive, there is, after the first redress, which would be to challenge a decision made individually about me, also the possibility, if I'm not satisfied, to start a claim. And there we propose to have the possibility to be represented by people like James, which then, of course, helps everyone and would be, in a way, I guess, a collective right. And I think it's fine to stop here.
Thanks. Brilliant. So we're now going to collect some questions from the floor. and just go around the room. So let's start from there. And so we'll take 3 questions, let them be answered. Please state your name and who you'd like the question to be answered by.
Thank you very much. My name is Aida Ponce del Castillo, researcher at European Trade Union Institute. So, of course, a question to the Commission. Thank you very much for the Platform Work Directive, but why doesn't it have the portability right for workers working in platforms? Very useful. Second question, why, if employers/platforms have the obligation to conduct risk assessment on the algorithmic management, why didn't you put something if they don't do anything? Because if they don't conduct risk assessment, there is no absolute sanction at all, so fine. And the third one, on the Article 22, well, I mean, if it's really a nice way to bring it to the worker, to the labor law, it's completely impractical because you didn't solve the impracticabilities of the GDPR. And for example, why didn't you put limits on algorithmic management? Why do platforms have to inform that workers have been suspended or that their accounts have to be inactivated? Why didn't you just limit it and said suspension of accounts is not allowed, is prohibited? And of course, the burden of the proof is not on the worker, because it's impossible to prove something that they cannot see. Why isn't there in the hands of the employer, of those who are organizing the algorithmic management? Thank you very much.
Can I reply immediately before I forget everything?
I can rephrase the question for you, but sure, go ahead. Yeah. Very quickly, 15 seconds.
Yes, because it was a host of questions to me, and otherwise I would forget if we collect all the questions. Okay. And really quickly. So on the portability, I don't know. Now I have to confess, the leading service was DG Employment. I work in DG Justice, and I don't even work in the data protection team. So I'm sure there are considerations with the data portability that concern not only one worker, but possibly also, for example, their clients or whoever they interact with. So there could be some challenges, but I do not have a solid answer here because I was not part of the team drafting this. Sorry for that, but of course happy to relay the question. Then why don't we limit algorithmic management as such? I think this question can be asked if you think of it as per se a bad thing. But we also know from the impact assessment that some people actually appreciate they get access to work, which is for some populations difficult. There are benefits in having these services. And of course, the aim is not to prohibit it, but to improve the conditions of the people working through it. And I think on Article 22 being useless, yes, in a way, because it's a prohibition with exception, and one of the exception is if this is necessary for a contract. And all of these working through platforms is defined as I have a contract with a platform. So yes, it falls just perfectly plainly in this hole, and that's why we regulate or propose to regulate what would happen within that. On the suspension of accounts, that would of course be one of the things that the platform then has to give written reasons for in a defined time frame, and that can then be challenged. And we added all the instruments to be able to challenge it, and then maybe when the AI Act also comes, there would be a better evidence base. So the idea here really is to provide remedies where things go wrong, but we also can imagine suspension of accounts that are justified and where the people would not even want to go against it, because let's say they have been inactive, and for environmental reasons, the account is just being suspended instead of keeping the data in some server form forever. And then it might be totally fine for them. Okay. So.
We're going to take someone in the middle there. Yeah.
Hi, thank you for the debate. I'm Nicolas Blanc, national delegate for a trade union in France, whose name is CFE-CGC. I'm also an IT expert, and I'm a part member of the expert group GPI, Global Partnership on AI of the Future of Work. So my question, before all this works, Platform Directive and AI Act, don't you think we should enforce the Article 88 of the GDPR? Because I think it's very important for a trade union, and there is no existence. So I think it could be very interesting to enforce this article. So I would like your opinion about that. Thank you very much.
Thank you. We can have one more question. Is someone walking towards it? Oh, okay. Sorry. Yeah. René, please.
Hi, I'm René Mailleux. Thanks for and I'm working on the right of access, in particular in the GDPR. And I had a few, but I think very short comments. So one notion that I heard stated very clear by James, it's like the GDPR and its rights, they are not for us. They are for individuals, they are for consumers. And I think that's not true. I understand that you think so, because the way that we as a profession and the way that also the European Commission generally communicates about the GDPR and data protection is as if it has this very specific purpose, which then also is not very clear. I think, and we can see it very clearly historically, because we actually have these rights, not all of them, but most of the most important rights already since the 70s, they are really intended for all kind of marginalized or groups that need to be empowered, including workers. So I think it's important for us as a group of professionals to really keep on repeating that. Also for the Commission to say that, and for people like Anton or in your case, for the judges, I hope that it will not be presented as, oh, this is a nice, interesting kind of edge case where accidentally we can use this right in a kind of collective setting, but that it will be recognized and talked about as if, yes, it is applicable here because it's meant to be applicable here. And yeah, so it's actually a bit of a question to Anton, if he thinks that in the discussion with the court, is it going to go that direction? Is it like accidentally this applies, or this is supposed to apply here and the GDPR is just functioning as it actually should?
No, I think you're completely right. I think the court also knows this and acknowledged that the access rights have a very general scope, and there was a lot of debate about the reasons why the drivers wanted access to their data. And I, at some point, said to the court, well, it's very interesting to discuss this, but in the end it doesn't matter, because the data subject does not have to show why data is relevant or why they want it. They just have a right, if it's personal data. So it's the only thing and they said, yes, we know that, but we're just very interested. So I hope that gives me a positive feeling. So yes, I agree with everything you say, and I'm quite sure it will not be regarded as some exceptional application or whatever. Yeah.
Great. Thank you. Does anyone want to answer the Article 88 question? James?
Well, I just want to answer René. I agree with René 100% also. And I do feel about Article 22 in the way that you do. But the point I was making was about the presumption. The presumption isn't there for us, and we have to fight for it all the time. And so, the institutional stasis, if you like, is against us. We have to make our case, and the controller, their position of presumption is you're not entitled to it, and we have to fight for it.
With regard to Article 88, I'm quite sure not everybody at this table knows exactly what's in this provision. I know it's about labor law regulations, if I'm not wrong, mistaken, and I think it gives a possibility to member states to make further rules regarding processing of data in labor law relations, right? And collective agreements, apparently. Well, would it be a good idea to enforce this? Yes, of course. But maybe Aida can comment on that, but I don't really know how to respond.
Yeah. Yes, I'm very keen on replying, because to enforce something, you need to have something. And Article 88 is exactly the opening clause that enables to have new law on labor and collective issues. And so in a way, that's exactly what the proposed directive is meant to do. Implementing it rather than enforcing it. So then we have something to enforce.
Okay. Yeah.
Thank you. How are we on time? I'm a little... Oh, brilliant. Okay. Michael.
Now
And after Michael, the lady in front of you. Yeah.
Thanks for this panel. Platforms often use quite destabilizing approaches to battle use of rights. They might change the data forms, they change the formats and all sorts of things. And they'll say, you know, well, our system is developing, we're developing our practices. Is there anything we can do about this? Is there opportunities to use the fairness principle in data protection law? Are there other opportunities? I'm not sure how to regulate destabilization and other platform mechanisms that you will be aware of as a panel, I think, to try and deflate the power of these rights in practice. Thank you.
Is there someone else? Thank you so much. This is Maria. I would like to know if the AI Act would cover also employees that are working not just from the European Union, but working in different other countries. And because, why is this important? Because usually this, like for instance, multinational companies, they use the same AI system. So now that we are talking about collecting, maybe unions can request the employer to know how the AI system works in this case. Thank you.
Great. We can start with the first question, maybe. How do we deal with, I suppose, maybe the randomness of platforms' effects on the users of workers?
Yeah, you mean, I think Michael was saying that they find all kinds of ways to make the process very complicated. I think James knows best all kinds of ways they're doing that. Mm-hmm. Yeah. So, before you say, so you go. Yeah.
No, I said the answer is, what do we do about it legally?
Well, I remember during the hearing, I invoked Article 12 of GDPR, where it says that I don't know exact the phrasing, but the data should be provided in an understandable and clear way. So in our case, James, you can help me, but they use this phased approach, right? Maybe it's where they first send you an email, but it contains vague language, which somehow they say we're giving you data, but at the same time they're asking you to give a more specific description of what you want, and then if you don't respond to that, they'll use it against you in court. Am I saying it is right?
Yeah, it's not for me. It's not destabilization. It's active suppression of the right. Is this what's going on? In exactly what Anton described, creating confusion, and it's vexatious, and it's a frustration of the right. And also, I think it's a particularly sensitive thing to do in the context of labour, because there's already a power imbalance. And if somebody, turns to their trade union or civil society organisation to help them make this request, and then the controller goes over the head of the union to go back to that data subject to say, "You sure you want that data? What do you want it for?" and so on. That's quite intimidating thing to do. But there is this issue about the layered. I mean, what Uber says is that they take a layered approach to, so they're curating your fulfillment of subject access requests, but there's no guidance on what that fulfillment looks like, what the curation is. And the EDPB guidelines talks about this being okay. I don't think it's okay at all. I think it's terrible, because we don't know how those decisions are made about what's been given to you and what's been withheld. I think that's completely wrong, and it's a huge problem to take this sort of layered approach. And also, I'll give you an example of a really misleading one. In Uber's portal, they describe giving you event data, and event data can be really important if you're accused of fraudulent activity, and say this is the detailed device event data. But we now know that the event name, the event type, the last user action that triggered the event is stripped out of it. So they're giving you an event data file that's been completely stripped of all context of what event has happened.
Can I give you one more example? So what happened with the subject access requests? First, my clients made a subject access request. Then Uber answered it. Then I made a court request because my clients felt they didn't get all the data. The day after we filed the court request, Uber said, well, but we have more data. So they give more data. And then in the court they say, those requests were too early. We were not finished giving the data yet. Come on.
Yeah.
It was quite nasty, but fortunately the court ignored it. So.
And I also want to turn to Jill for this. I mean, you've already noted this imbalance, right? Kind of in terms of who has access to what kinds of data, who gets to control the narratives, even in legal situations or court decisions. How might we go about setting that right? I mean, if we can't, is it simply about enforcing the regulation that we have, or is there something kind of like a structural imbalance in the ways in which these platforms hold power and are able to exercise it, even in what should be a fairly obvious situation, like give us the data and they're like, actually, no, we're going to change it and not give you the data. Where's the problem coming from here?
I mean, I think the problem comes from like many areas also, and I think you asked also whether the AI covers that. Like, no, the answer is no. I think the larger question also, and I think there are principles in the GDPR, like data minimization, or banning, having red lines on certain technologies. I think that kind of perspective should be pushed further, and not take the assumption that we need certain technologies, or because I think that's the thing, right? You create more data, so you need more access to data. It's like an endless loop of, okay, you want to talk about access, okay, but then why are certain systems being used in the first place? Why is data being collected in the first place? What is the role of these technology companies in our lives? Like, sure, you can, and if you talk about it from a consumer perspective, yeah, okay, you have certain new services, and the question is, do we need some of these services? So what I find interesting about the labor perspective is that, I mean, I think all of us have experience being mediated by technology in different ways, and you ask yourself, do we really need that? And at what cost are we willing to continue this conversation, including in Europe? Yeah.
Thank you. Right, and I'm just going to paraphrase the final question maybe and ask a little bit, can workers of the world unite? But really, I mean, we were having this discussion about how for certain for data access rights, you had to go back to Ola based in Uber, and you saw based in India. And their data management practices were completely off the rails and obviously not compliant. And GDPR has this kind of, Europe has been always with the Brussels effect kind of exporting its standards for AI regulation or technology regulation for a while. So the practical question, maybe Aika can answer whether the AI Act actually would cover workers outside of the EU, and more broadly, kind of, what might the implications be for transnational technologies in this way?
I think the question was about the platform directive, where the answer is no. The work has to be performed in the EU, otherwise it's not in scope. Mm-hmm. And that's, of course, one hurdle for the workers of the world to unite, but for the workers of Europe to unite, I want to mention just one more provision. The platforms have to provide for a communication channel for the workers, because if they have no common physical workspace, it's a challenge to find your peers. And so there would have to be this channel. And then either if they don't want to be monitored, they take it elsewhere, or they continue to talk there. But I think that's an important point on that.
Can I react very quickly? Yeah, I think like if you look at the trajectory of like union busting strategies, that particular provision is actually quite scary in being able to communicate. I think the essence means well, but I feel that like that means that more very sensitive organizing kind of data is going to be in the hands of particular systems and companies.
Yeah,
so
I don't mean to sound naive, but there is also a provision that says you should not predict when... No, actually, I don't remember now if did someone suggest to include that or if it's so scrap that. But I want to say, okay, that's why first time I spoke, I said, yeah, you can have the channel to find your peers, and then you can decide if you continue to talk there or if you rather take it elsewhere. to another platform. Yeah.
Brilliant. And we are on time now, so thank you so much. I really, I thought this was a really generative and really wonderful conversation on something I think that is, you've been working on it for a while, but so much of the GDPR conversation is not focused on these elements of kind of collectivizing, of kind of bringing, talking about marginalized populations and how they might claim their rights in the broader context in which we're exercising them. So it's been a fascinating conversation and a pleasure to moderate it. Thank you so much, and thank you to everybody else.